Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. Today we look at benchmark CG 3.4, in which we will explain the relationship between state and national governments as written in Article 4 of the U.S. Constitution and the 10th Amendment. In Part 1, students will describe the system of federalism as established by the U.S. Constitution. Here, students will describe the system of federalism as established by the U.S. Constitution, as noted in benchmark clarification number 1. The system of federalism under the U.S. Constitution is a system of government where power is shared between the central government, also known as the national government, and the states. Federalism presents the interaction between the national and state governments and between the state governments. So in essence, what we have is a shared power system that is identified and outlined in the United States Constitution, and not only is power shared, but part of both of those entities functioning, the national government and the state government, also requires that they interact in particular ways in order for each to carry out their stated constitutional function and responsibility. First, we begin with Article 1, Section 8, Clause 18. This is called the Necessary and Proper Clause. Article 1 of the U.S. Constitution focuses on the powers of Congress. Article 1, Section 8, Clause 18 is the last clause in Section 8. Section 8 is the longest of the sections of Article 1, and it articulates specific powers that are given to Congress, including responsibilities and options that Congress has. Section 8, Clause 18 says that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So let's discuss that a bit. What are the foregoing powers? The foregoing powers are those that precede, that come before Clause 18. So Article 1, Section 8 includes the power to tax. Article 1, Section 8 includes the power to raise and support armies, the power to declare war, the power to establish post offices and post roads, and many others. So these specific powers might require additional legislation in order to ensure that those powers can be carried out. And so this first phrase before that first comma makes this clear, that Congress, in addition to having the listing of powers included in Clause 1 to Clause 17 from Section 8, also has the power to make the laws that are necessary and proper for carrying into execution, for making the other powers come into being. Clause 18 also says that all other powers vested by this Constitution, meaning vested is held by this Constitution in the government of the United States or in any department or officer thereof. And so what this is saying is that Congress has the power to use its legislative authority to do what it is that it needs to do in its own article, Article 1, Section 8, as well as other articles and other sections within Article 1. Because if the power is vested in the Constitution, and certainly the framers of the Constitution could not anticipate every possible need for the government and for the society 200 plus years later, that the necessary and proper clause gives this flexibility to Congress to do what it needs to do in order to fulfill its responsibilities. But we also have Article 4 of the U.S. Constitution. Article 4 of the U.S. Constitution is important because after reading Article 1, Section 8, Clause 18, we realize that Congress might decide to make laws affecting the states using its necessary and proper authority. But what about states interacting with one another? What does that mean and what does that look like? Well, this is where we see something called the full faith and credit clause. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. So this is kind of interesting because in essence what it's saying is that there are certain public acts that we might experience where we live that don't have to be repeated over and over and over again should we move to a different state or even travel to a different state. So imagine if a couple were to get married and a marriage license is issued within the state government. The state set up the requirements for marriage as to how long before somebody gets married they have to apply for a marriage license. If there's a minimum age at marriage that should be considered, that might be different across different states, and other criteria. That marriage must be recognized in another state so that if a couple moves from one state to another state, they don't have to marry again in order to then enjoy the benefits of marriage or to be married. Similarly, imagine if a child were to be adopted and it's through the state court system and the local courts that secures that adoption. Well, that child doesn't need to go through the adoption process again if their family moves to another state. However, Congress may decide that there are certain pieces of this relationship between the states that can be regulated by the national government. And then making these regulations by the national government is then going to impact what can happen across the states. So one of the laws that is passed at the state level is gasoline taxes. How much a person pays for a gallon of gasoline includes gas and the taxes associated with it. Some states have higher gas prices because they have higher gas taxes. So if Congress were to set a minimum or a maximum amount that could be taxed on gas, that would take that power away from the states as to how much they could charge in tax. Same for an income tax. Some states have income taxes and some states do not have a state level income tax. But what if it were to happen that Congress were to decide that no state could have an income tax? That's going to really have an impact on those states that depend on those income tax dollars to provide certain services to the residents of those states. Next, we look at the Supremacy Clause, which is included in Article 6 of the U.S. Constitution. Now, we may recall that there are 7 articles in the U.S. Constitution, and the 7th article is only a single sentence. It's about ratification of the Constitution. So I find it interesting that Article 6 comes at this point. This particular Supremacy Clause comes sort of towards the end of the document. So it was an interesting strategy on the framers' part to put this requirement to the states to ratify the Constitution, and they waited sort of till towards the end of the document in order to make sure that the states who were ratifying the Constitution were aware that the federal government would be supreme over the states if there was a conflict between the states and the national government. So here it says, the Constitution and the laws of the U.S., all treaties, etc., shall be the supreme law of the land, The judges in every state shall be bound, anything in the Constitution or the laws of any state notwithstanding. What this means is if there's a national law, such as a national minimum wage, and a state wants to provide pay less, a lower minimum wage, that means that the higher minimum wage from the federal government is what's going to be put in place. There'll be no discussion, no debate over which minimum wage is better for the economy. It's the supreme law of the land. The United States is the supreme law of the land. And then the last document that we look at is the 10th Amendment. The 10th Amendment is part of the U.S. Bill of Rights, and it says the powers not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So what this is saying in language that we are more familiar with is that if the Constitution gives powers to the United States, that's delegation. Delegation is assigning something to someone. So if the powers in Article 1, Section 8, they are assigned to the national government, and if those powers are not prohibited to the states, then the states can do whatever they want. So if there's no national law on a particular topic, and there's no prohibition on the states making laws about a particular topic, then the states can do whatever they want. And so one of the ways that I think about this is that, in essence, the states are closer to the people. So there may be some issues that may be of particular interest to people in Florida that are of less interest to states that are not surrounded by water. And so the state of Florida can make laws in the absence of a federal law, and as long as they are not forbidden from making a state law on that particular topic. So this is what we call the reserved powers clause. The reserved powers meaning these are powers, the states have unlimited powers, except the limitation is whatever is given to Congress and what Congress forbids the states to have. Thank you for joining me for Middle School Civics Highlights. If you still have questions, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.